Well, thank you for staying with us here on Global Television. This is how we welcome you to this edition of Scale of Justice. I'm Uyi Agmofwebe. We'll turn our attention to the challenges associated with enforcement of court judgments in Nigeria. Over time, we've seen so much of bottlenecks in that direction. We've seen lawyers, we've seen everyday citizens also express frustration regarding this, if you like, unpleasant development, which has been here for such a long time. However, in the middle of all this, we're seeing the law evolve time and again, either by way of constitutional amendment or in some cases, landmark judgments from, in particular, the Supreme Court of Nigeria. In any case, to what extent has that made it easier or otherwise for litigants to enforce court judgments, particularly as it has to do with maybe judgments that are secured against institutions or some agencies of government? That's our focus on the program today. I'm joined by Jeremiah Menchaya. I hope I got that name correctly. He's a lawyer and a political analyst. So I'd like to say a big thank you to you for coming on the program.
Thank you very much for having me.
Great. I'd like us to start with, maybe in the course of this conversation, you'd like to share one or two experiences, but let's talk about overall the challenge associated with enforcing court judgments in Nigeria.
All right, thank you very much, Uyi. Court judgment generally, like any other endeavor, once a litigant who has gone to court to express his grievance, is successful, it is expected that he, benefit from the outcome of his success,
right,
which is the judgment. But oftentimes you see that we have challenges with people having to enforce some of this, especially, when security agencies are involved, and this is much more pronounced when it is, when it has to do with monetary judgment. We have criminal judgments, criminal matters,
right,
and civil matters. So within these civil matters, we have matters that are maybe the subject matter is land. We have matters that the subject matter is, monetary, tied to money. You have civil matters that maybe the subject matter is tied to employment related. So some of the ones that appears to be very problematic are the ones that has to do with financial, the subject matter is finance, is dealing with, money.
Maybe transactional in nature.
Transactional very well, if you have it. You have some situation where somebody has gotten judgment, let's say, for example, the police.
Right.
And you want to enforce, most of those challenges are there, ranging from, non-compliance of the security agency involved to, bureaucratic bottlenecks, to the legal impediment itself, So there are all these factors are put together, and then it has been very, very problematic in the past.
Very, very interesting. But let's focus on the ones that have to do with, let's say, you secure a court judgment against an institution of government. It could be the Central Bank of Nigeria, for example. It could be the Federal Inland Revenue Service. All of those key agencies of government. How bureaucratic it is, maybe administratively speaking or otherwise, for you to be able to push through with enforcement of such judgments. Because we understand we have quite a number of them now running for several years, some of them for a few decades. We even hear there are cases of such nature that come from the military days, maybe in the 90s or something. So, how challenging is that process?
All right, thank you very much. Okay, so, because in Nigeria, we practice what we call accusatorial system of government, of legal system. So the person who accused you of doing something must prove.
Right.
So at the end of the day, once you go through the legal system and you secure a judgment, like I was telling you, it is expected that you will benefit from this judgment. So most times, because of the legal, or let me say, the precedents have been laid by a couple of cases, it was a bit problematic for lawyers, for litigants, to be able to get to do with some of this enforcement. I will give you an example, like Section 84 of the Sheriff and Civil Process Act, which is actually the law that deals with enforcement of judgments in the country, in Nigeria. So that section, it provides that any judgment which is to be enforced against a state or against a public officer must, and as a matter of routine, you must seek and obtain either the consent of the Attorney General or the leave of court. In this case, so that in the past, appeared to be a very big, problem, because sometimes you apply for the consent. Is either the Attorney General is not in office to grant you the consent on time, or because you and I know that the Attorney General is a politician, a public servant who is usually appointed by the president.
Right.
And because of that, sometimes he will have to do the interest of his appointer. So it's either for one interest or the other, he may delay the consent. So it becomes problematic for the person who is involved in the matter or who has gotten judgment in his favor, who ordinarily it is expected that he will reap from the fruit of his labor. And also, there were cases in the past, like if you look at the case of Central Bank of Nigeria with Ochefe, which was delivered by the Supreme Court in January 2025. The Supreme Court tried to restate the position and that authority, actually, that for a litigant who is coming to court to enforce his judgment against a state or a public institution, a public officer, we call it in Latin custodial legis, which is the custody of a public officer,
right,
or the funds and the custody of a public officer must first seek and obtain leave. But as time goes on, the Supreme Court was trying to solve, the mischief that position, that section was causing because at the end of the day, justice, like Lord Denny says, one of the most respected jurists in England, says that justice must not only be done, but must be seen as being done to the ordinary man on the street. So the Supreme Court, in trying to cure some of these, mischief or complaints of the people, are now trying to water down the strict provision of that Section 84. And this, manifested itself in the case of Central Bank of Nigeria versus Sinistella Services Limited. And in that case, the Supreme Court tried to introduce an aspect which says that if the Attorney General of the Federation was already aware of the dispute leading to the judgment,
right,
then there may not be necessarily, the need for him to grant consent. In other words, he was already aware of the issues that gave rise to the judgment.
Yeah.
But this, this authority was not conclusive. They still gave room to a lot of interpretation until January this year.
So much of ambiguity.
Ambiguity, thank you very much. Until January this year, then the Supreme Court again was called again to interpret that Section 84 in the case of Central Bank of Nigeria versus Lidan Industries Limited and 4 others. And I think the brief of the case was that this was a case where somebody who was a contractor imported some containers abroad. So the Nigerian Customs Service, in the process of clearing this container, auctioned greater number of them, either consciously or unconsciously. So the man said, no, look, this is wrong. You can't do this. So there was back and forth, and he went to court. So the trial court gave judgment in his favor, and then Nigerian Customs Service could not even appeal the judgment on time until after the man was making attempts to enforce the judgment. Then I jump up and filed an appeal at the Court of Appeal. So the Court of Appeal was called upon to interpret whether in this case they could benefit from the law to stop them from complying with the judgment of the trial court. So the Court of Appeal said, no, you are aware of this judgment since 2004. You kept quiet until 2012.
You came
2012, yes, actually. Then you are now coming on board to bring a preliminary objection to seek to stop the successful party in this case from benefiting from the fruit of his litigation. The Court of Appeal said, no, they can't do that. So they went back to sleep as usual. So the judgment creditor, in this case, which is the person whom the judgment was delivered in his favor, now sought to enforce the judgment. So he discovered that most of the respondents, the Nigerian Immigration Service and all of that, had account domicile with the Central Bank.
That's the Nigerian Customs Service.
Nigerian Customs Service. Yeah, so there's a procedure that we call garnishee proceedings, which if you want to enforce a monetary judgment, you have to go through. It is a completely different procedure from the main case. You can go to any other court and ask the court to direct the bank where the party upon which you have gotten judgment against, where his money is domiciled. You can ask the court to direct the party to show cause why the money should not be more like forfeited to the judgment creditor. Right. Okay, so the Central Bank, instead of doing that, instead of showing cause why this 390 million naira, which was a judgment sum, to be transferred in favor of the judgment creditor, now raise a appeal saying that our consent was not sought and obtained before this garnishee proceedings was brought. So the Supreme Court again now rose to the occasion and said no, that Supreme Court in this sense cannot strictly be categorized as a public officer, in the sense that they were doing their duty of a banker to the federal government and not as a public institution so-called. That's in this case, they were called upon to act as a banker of the federal government. So their duty only arose in this sense to perform their banking responsibility under Section 4 of the Central Bank Act and Section 6 of the Central Bank Act, 2007. We say that the central bank is the banker of the federal government and the federal government institution. So as we speak, that is the subsisting judgment on the procedure to enforce monetary judgment in the country.
As it stands right now, I mean, such a brilliant explanation you've done with all of this.
Yeah.
Are these challenges altogether constitutional? Are they problems with our constitution, or is it just a matter of interpretation?
All right, thank you very much. Well, the constitution itself did not, expressly, provide a procedure for enforcing judgment. But like I said, the only thing the constitution have said is that, judgment must be delivered by a trial court within 90 days. After a matter has been concluded. So, but then there are other laws, as of the National Assembly, like the Shares and Civil Process Act, which I've mentioned, which have dealt with the matter. So, all this while, the courts have only been trying to wriggle out the intention of the legislator while making that law. And the Supreme Court have said clearly, like in the case I've mentioned, in Ledan's case, that the intention of the legislator is so that government agencies will be aware that the government money in their possession is going to be attached or garnished by a judgment creditor. So the whole thing is to try to eliminate surprises.
Yeah.
So I think that is fair. And it will go a long way. But there are other factors as well apart from this legal impediment that I've caught.
Right.
We'll talk about the length of appeals. The length of appeals.
A long time.
A long time, a very long time, because the Constitution says that everyone whose judgment has been delivered against has the right to appeal. You can appeal the judgment of the trial high court, either high court or federal high court, to the court of appeal. Then thereafter, if you're not satisfied, you can appeal to the Supreme Court. So discover that before your judgment is delivered at the high court, before you transmit records to the court of appeal, then before the matter, you are given the date and the appeal is heard and judgment is delivered. If you're not lucky, sometimes it takes roughly 5 months. So a litigant will have to wait. And then from there, if you're not satisfied, you also have the right to appeal to the Supreme Court. And I thank the Supreme Court's attitude these days. They are trying as much as possible to streamline the number of the appeals that goes there. But as a matter of fact, I see that as also an impediment. Then you talk about the financial constraints.
Right.
As well. You look at somebody who maybe, has gone through a long rope of litigation at the trial court. Maybe he has paid, monies here and there for legal services, for gathering materials to prosecute his matter. Then he has to do it again and again at the court of appeal, get to pay lawyers' fees and all of that. And there are some costs that we even expect you to deposit security in form of money to show that you have a substantial matter to be tried by the court. For example, if you're appealing a monetary judgment at the court of appeal, they expect that there's a money which you will deposit before the court.
That's some sort of security or something?
Yeah, security to ensure that you did not bring frivolous matters before the court of appeal
and waste the cost time.
Exactly. So these are some of the challenges. But then also talk about the challenge of attitudinal, or let me say, the character of the security agencies themselves. There are some security agencies in this country where if you are going to enforce judgment against them, even as a lawyer, you know that you are going on the white ghost chairs. For example, let me say the army. If you got judgment against the army, for me, maybe sometimes getting to serve them court process is problematic.
Just to serve court process.
So process.
Not to enforce judgment.
Not to enforce in this case. Sometimes the Department of State Security Services, for example.
The DSS.
The DSS. If you go to their office, sometimes they will tell you, lawyer, you can't come in here and serve process for now, and all of that. So those issues are there.
What are the remedies for such situations? What are the alternatives?
The alternative open to a litigant in this case, you can cite the head of those agencies for contempt. Of course, I remember the attitude of some of the Federal High Court judges. Recently I was hearing that the Attorney General has been ordered to appear and show cause why he should not be committed to prison. So the laws actually has provision for everything anyway. So at the end of the day, if you get judgment against let me say the Department of State Security Services, and you have served them the judgment, and they are refusing to obey, the law says that you can go back to the court because the court gave the judgment, and the court must have a mechanism to punish those who refuse to
flouts
obey
decisions.
exactly to obey his judgment. So the court will order the head of that agency to appear and show cause why he should not be sent to prison for disobeying judgment of court. So we call it Form 48. You serve them for 48. Which is like a content proceedings forms to come and appear and show cause why Form 49 should not be issued. And once that Form 49 is issued, then it is a committal order that you will be sent to prison, to prison directly. But sometimes you discover the implementation is still a thorny issue, really, because assuming going against the whole Director General of the Department of State Security, is it the police you are going to use to bring him to court?
Who's going to enforce it? We saw that on multiple occasions with the former IG in this country.
Exactly.
We saw that with the former Chief of Army Staff. But
exactly.
None of those, court orders were carried out. But I want to ask you specifically about things like class action.
Yes.
If maybe by way of a class action you secure judgment against a public agency, is it the same procedure? Is it with the same kind of difficulty?
Yes. A class action entails that so many people coming together.
Right?
Yes,
right.
to initiate a suit. So the law is so far as the law is concerned, the law categorizes you as person. It
As
could
an
be one. Yes, it could be one. It could be many. The same procedure is applicable to legal personalities.
Right.
Because in law there are two categories of persons or that can institute an action. We talk about natural and artificial persons. Natural person is me and you. We are natural human beings. Then artificial persons are companies. You have incorporated trustees. You have NGOs, corporate trustees are NGOs, all 400 corporate trustees. Companies limited by guarantee, private or public companies. All of these are, they are in the bracket of artificial persons, so they can sue in their own name. So in the process of doing that, they may decide to do it individually or in group. For example, we also have another category that we call representative action. Maybe, for example, we are in a community of elders in this village, and we're having this with another community. Instead of us packing ourselves to go to court, we can delegate Maxi, so person to sue for our behalf, exactly, of the members of the community. So all of this we call class action. So far as the law is concerned, you will still follow almost the same procedure in enforcing some of these judgments if they are gotten. But let me also say this, that the major responsibility of security or of security agencies in this country is to protect lives and property of the citizens. And if you look at Section 14 of the Constitution, it says that the major policy thrust of every government should be to protect lives and property of the people. So I think that security agencies should do more in seeing civilians or citizens as their, the people which they are holding those positions in trust for, rather than being naive when issues of enforcement of court orders are brought up. You get, because if you're a policeman or you are an officer of the National Security and Civil Defense Corps, or whatever position you are holding the position in trust for the Nigerian people. The power is delegated to you by the President and Commander-in-Chief of the Armed Forces, and you are expected to hold it in trust for the Nigerian people. And if you look at Section 4 of the Police Act, for example, it says that the police must ensure the protection of law and order, must ensure that at all times that there was a protection of law and order, and conduct that are likely to breach peace should be dealt with. And the same thing is applicable. Look at Section 6 of EFCC Act, for example, which also gives EFCC a similar mandate to investigate all financial crimes. And this thing is applicable to, look at Section 3 of the National Security and Civil Defense Corps Act, and the same thing to NDLA Act. So all of them in one accord almost have the same mandate, which is to protect Nigerian people, to protect Nigerian people's lives. So they should be the custodian of the law. They should be in the forefront of ensuring that there is compliance with the law and procedure.
As it stands today, would you say our legal system, or if you like, our judiciary system is complicated, it's complex? Because I spoke with somebody recently who came from England. He said what they have there is not constitution as we have. Yet they have a system that is seamless. The law takes its course as quickly as possible, but in Nigeria things drag even with our constitution and all of the amendments we've been making. In fact, both the Senate and the House of Representatives have standing committees on constitutional review, yet it appears legal process continues to be protracted. What are the factors responsible?
Oh, well, thank you very much. I think that's a very good question. Okay, now, so you look at the nature of the Nigerian legal system. You know, our system was gotten from the American system of justice delivery,
right?
And then we incorporated our own cultural aspect into it, our own traditional methods into it, such so that if somebody has gone to to read law in UK, for example, and is coming to practice in Nigeria, he will have to go through another additional training so that he will be well versed with the Nigerian legal system, with Nigerian customary laws, which are part and parcel of the Nigerian legal system.
Right.
So for example, if you are going to read law in UK and you come back here to go to Nigerian law school with me, who has gone to maybe a university in Nigeria, I will directly go to bar part 2 to go and read law directly and be called to the bar. You will first go to bar part 1, then you'll be taught legal system before you qualify to bar part 2. So it's because of the intricate nature of the system. You talk about the issues of jurisdiction,
right?
And that takes me to legal expertise, which I wanted to mention earlier as a challenge. You discover that sometimes some of the litigants lost cases due to lack of legal expertise. Either maybe the lawyer was not diligent enough or did not pay much attention to issues of jurisdiction. You discover, okay, now there was this prominent case of Ibori versus the state. I'm sure you have heard of James Ibori.
The very classical Ibori versus the state.
Exactly. So Ibori was charged for money laundering before the Federal High Court in Kaduna.
Right.
So the Federal High Court now said, no, look, under the Federal High Court Act, you must establish that there is no Federal High Court within the jurisdiction upon which that offense is committed.
And that was not the case.
That was not the case. In the Ibori's case, there was a Federal High Court in Delta State.
Right.
So the Federal High Court declined jurisdiction to entertain the matter and struck it out. So this was a clear case of lack of territorial jurisdiction.
Now, what could have been the motive behind such an action? I mean, taking the case all the way from Delta, from Edo, and the entire region to Kaduna State. Was that political?
Well, I would not say it's political. I think sometimes it could be lack of proper application of the law. Like I was saying, I think some of these security agencies, need and before the coming on board of the Administration of Criminal Justice Act,
the ACJA
15.
Right.
Thank you very much. Remember that non-lawyers could prosecute, especially at the magistrate court for police. So far as you have gathered considerable number of experience, you are allowed to prosecute until the ACJA now said, no, look, it must be lawyers and lawyers alone that should prosecute, especially in all the courts in Nigeria.
Top to bottom.
And so in the past, we had issues of expertise. Maybe the lawyer may not necessarily be aware that there is a section in the Federal High Court Act that says that you must go to a Federal High Court within the jurisdiction. Even amongst lawyers who are learned. Okay, I will give you a very local classic of the case of Ahmed Lawan.
Right.
Versus, it was a political case where Ahmed Lawan, the then Senate President, I think it was an issue of, nomination, where him and the Honorable Bashir Machina battling from issues of nomination.
Right.
Ahmed Lawan.
Yobe State.
Yes, thank you very much. Yobe State. Ahmed Lawan was contesting for as president of the country. And so because of that, Machina's contention was that Ahmed Lawan could not have possibly contested for primaries of the APC in Yobe State. So he challenged that the High Court of the state, of the Federal High Court in Yobe, the matter went to Court of Appeal and finally at the Supreme Court. So what Ahmed Lawan did was was not the legal thing of Ahmed Lawan, which I appreciate them more because of their brilliance.
Right.
Is that they did not bother themselves to look at the substance of the matter. They went to look at the loopholes they could exploit. So they discovered that procedurally, Machina didn't do the right thing. The law, as we have it today, is that if you are bringing an action in which the facts are contentious, where the parties are arguing about the facts, nobody is agreeing that this is what happened, you must come by writ of summons. Because there are about 5 methods with which you can bring a case to court. We have writ of summons, we have originating summons, we have petitions, we have complaint, in some cases, and originating motion. So you use originating summons, originating motion, where the facts are non-contentious. Everybody is agreeing that this is the fact. Maybe what you are telling the court to do is the court to help you interpret a section of a law,
right,
or maybe a will or a document. But in this case, the contention was that whether or not Ahmed Lawan contested for primaries in Yobe. So the facts were cankerous, they were argumentative, if you want to say. So the right mode upon which Machina was to have used was a writ of summons. So the Supreme Court simply said, no, we don't have jurisdiction in this case because you use the wrong mode. And if a case is commenced by wrong procedure, then if you look at the case of Madokolo versus Nkendele, the court lacks jurisdiction to proceed with the matter, and the matter was accordingly dismissed at that point. But the ordinary man on the street who was not versed with the procedure was like, injustice and all of that.
We'll be looking at it from a place of sentiment and emotion.
A sentiment, thank you very much.
Incidentally, that's the much we'll be able to take on this conversation, but we appreciate your very witty submission in the course of this conversation. I've been talking with Jeremiah Mchana. He's a lawyer and, of course, a legal analyst to help us find sense in issues around challenges associated with enforcing court judgments in Nigeria. Again, we appreciate your time with us here.
Thank you very much for having me.
And we at Mofwegwe, on behalf of my team, I say thank you for watching Scale of Justice. I'll see you again.